Thank you to everyone for coming. It is great to be up here. I actually love getting out of DC and going and seeing the various branches across the country. I've been here, I've spoken here multiple times before, and I recognize some of the people, although at the moment it's very difficult to see anyone. But you will notice, if you've seen me for a while, that there is less of me to love. That's about 25 to for me to love, and I'm thinking of going into business and calling this the Trump plan diet, because this is what happens when you spend all day scared, overworked, and unable to eat and just smoking cigarettes. So this is where we are at the moment. This is what I'm here for. I handle the legal work for the organization. I realize my profile very badly needs to be updated because it didn't mention the biggest thing that we've done legally for quite a while, which is the lawsuit we filed against CVS, the retail pharmacy stores, for how they market homeopathic products. I don't have a vast amount of news I can actually share on that. Things are happening on that. In fact, next week I have a second settlement conference with CVS and their lawyers. So hopefully soon I'll have some information I can impart on that. But we will be looking at other retailers and looking at other ways of using the same consumer protection law to go after these scientific mumbo-jumbo. But that's not what I'm here to talk about tonight. I'm here to talk on a much more general level about the situation in the country. And the talk is entitled The Good, the Bad, and the Ugly, Secular Litigation in a Post-Kennedy Supreme Court World. And as I'm flying up here, I'm thinking to myself, why did I call this Good, the Bad, and the Ugly? Because as you're going to find of good for me to be talking about.
Hey, sorry to interrupt. Could you switch to this mic?
Sure.
Because that one's going in and out, and I want to make sure we catch everything you have to say.
So yeah, to be honest, trying to find good things at the moment is next to impossible. There are a couple of good things, and I'll mention them, but the bad, the ugly, and the oh my God, we're all going to die didn't have quite the same kind of ring to it as a title. And I kind of have a habit of naming things after pop culture references because, hey, that's me. So where are we at the moment? Living in DC or just outside DC, it is amazing over the last 2 years how the city, how the environment has changed, and that, because it's DC, impacts people way outside of the district and impacts people across the country. What impacts me in my practice and the entire legal aspect of church-state separation are the fundamental changes that we're seeing happening in the federal judiciary system. These are the courts that handle any case that arises under the United States Constitution. Most of your regular stuff, your divorces, your speeding tickets, most crimes are handled at the state court level. But anything to do with the federal Constitution will go up to the federal court system. So it's inevitable that the overwhelming majority of time that is spent talking about this is spent talking about the Supreme Court. 9 people. We're back to 9 after, almost a year and a half with only 8 members because the Republicans in Congress refused to even hold confirmation hearings for Merrick Garland. But we're back to 9 people. It's a slightly out-of-date picture because, as you can see, it has Justice Scalia, who passed away, who Obama tried to replace with Merrick Garland, who didn't get any kind of hearing. And then after the 2016 elections, we ended up with Justice Kavanaugh taking that seat on the bench. So what can we say about the current Supreme Court? what can we say in polite company about the present Supreme Court? This is, categorically speaking, the most hostile Supreme Court to the secular movement, to the secular community, to those of us who hold secular values. It is the most hostile Supreme Court in living memory. This is the most hostile Supreme Court since Chief Justice Warren took over and started moving the court towards in favor of individual liberties against the government. Arguably, it's the most hostile Supreme Court since the 1920s, the Supreme Court that tried to overturn all of Franklin Roosevelt's New Deal policies, and Franklin Roosevelt ended up having to threaten to court pack, to increase the number of Supreme Court justices to get his policies through, and we ended up with what's referred to in the legal community as the switch in time, where one Supreme Court justice changed his opinion and started accepting increased federal roles in there, a role in society. But this court, on pretty much every issue that those of us who work in the secular movement hold dear, this court is incredibly hostile. And perhaps the most important and damaging thing that they have been doing is a change in the view of what religion is in society. And today is National Religious Freedom Day. And it's National Religious Freedom Day because it's the anniversary of the passing of the Virginia, I'm blanking on the name of it, Thomas Jefferson's bill in Virginia on religious freedom. And the Supreme Court is claiming to be advancing religious freedom. And they're claiming that all the policies that they're pushing, the decisions they're making, are in line with the Jeffersonian notion of religious freedom. So it's really important we understand what religious freedom is and what the Founding Fathers and the writers of the Constitution intended religious freedom to be. Religious freedom is actually very simple. It's about the right to believe as you wish and the right to worship as you wish. It states that the government has no role whatsoever in determining your private beliefs. They can't punish you for holding certain beliefs, and they can't force you into holding other beliefs. And as part of that, what is essential is they can't favor any particular beliefs over any other set of beliefs. They can't fund those beliefs. They can't give them preferences under the law. And that's a notion of religious freedom that all of us in the secular community should support fully. Why do we support it? Because it's our people. It's the members of our community who tend to suffer when there isn't religious freedom in a society. If we look at Bangladesh, if we look at Pakistan, if we look at Saudi Arabia, much of the Islamic world, it's atheists and non-believers who are on the receiving end of so much persecution from the state on this. Religious freedom for all involves freedom from religion as well as freedom of religion. And it's essential for that. But that is not the way that the Supreme Court has in recent years been treating the notion of religion. They've changed this concept of freedom of religion from being one of the fundamental rights that our society is built on, from being this right for freedom from government influence to protection from government persecution. And they have been turning it into a sword rather than a shield. That religious freedom allows you to impose your views on other people, whether it's the notion of forcing children in school to pray as you do, whether it's teaching children in school the creation stories that are your religion, not anyone else's, or not even the scientific background to this. But what they've done is take this idea of religion and this right to follow your own religion, even when it impacts other people, and they've turned it into this kind of uber right, a right that is more important than any other rights. So instead of following what the Supreme Court did back in the 1950s and 1960s when we had civil rights decisions, and when it was first turned around and said that it doesn't matter if you're a private restaurant owner who turns around and says, it is my religious belief that the races should be kept separate and that I should not have to serve black Americans sat alongside white Americans because my religion tells me otherwise. Supreme Court listened to that argument and turned around and said it was as ridiculous as we can all tell it is. And they instead said, no, you can believe African Americans should not eat next to white Americans, but there is a law that says if you are a public accommodation, you cannot deny service based on race. And your religion does not provide you with an opt-out to that law. But no, what we're seeing now is this movement amongst the Supreme Court in particular, that you do not need to obey the same laws as everybody else if your reason for not obeying those laws is based on religion. Sometimes that only affects you as an individual. It turns around and it may arguably, it's been used to allow a Native American to take peyote as part of a religious ceremony. And on the one hand, that's not massively problematic. On the other hand, if a Native American can take peyote for religion, why can't I take peyote when I'm listening to a Grateful Dead album? If it's safe to do for religion and acceptable to do for religion, then it should be safe and acceptable for everybody. But no, religion has become this uber right, this right that trumps everything else. So if I don't want to make you a wedding cake because you're a same-sex couple, and I say it's because of my religion, I'm allowed to ignore the law that says I have to treat all people, regardless of their sexual orientation, equally in my business. It's the idea that if I run a business and I find contraception offensive to my religion, I don't have to provide insurance for contraception to my employees, whereas if my objection to contraception is based on anything else other than religion, I still have to provide that. It's taking religious objections and placing them up on this supreme level, which they have never been in the history of the United States. So there's a lot of problems with this. I mean, there's the initial problems that this is privileging religion. Another problem is that anytime you bring a court case and you go to the courts and you say, this bill puts a burden on me, this government law infringes my rights, the court quite sensibly turns around and says, well, let's look at that. How does it impact your rights? What is the harm that is done to you by this law? But that's no longer the case with religion. If we go back to the Hobby Lobby case, what the Supreme Court turned around and said is that if a person claims a religious burden, a burden on their religious beliefs, we have to take their word for it. That there's no way of checking that. That whatever they say the burden is the burden. So it doesn't matter if there is no logic, no science backing that burden whatsoever, that claim whatsoever. We cannot, as the judicial system, turn around and say, actually, you know what? That's not a very significant burden. And we saw this in one of the later cases to do with contraception, when Little Sisters of Mercy was one of the charities, Notre Dame University was another. They sued against the requirement, not that they provide contraception, but that they signed a form that said they didn't want to provide contraception. And they said signing the form was enough of a burden. And we, in the court system is no longer considers it able to turn around and say, sign the damn piece of paper. It's not a burden on you. So that's one of the problems we've gotten on this, is the idea that we let religion define its own burden. And there's a counter to that. If your burden isn't religious, the courts then look at it much, much more strictly. So there was a case recently, Gaza versus Hagen. There's no reason to remember the case name. But this was regarding a young Latina woman in detention, a minor, 16 years old, I believe, 17 years old, in an immigration detention facility who wanted to have an abortion. And that the detention facility was preventing her from having an abortion. And she challenged this, and a lot of organizations that we work with stood up supporting her. And the court turned around and questioned Justice Kavanaugh. At the time he was Judge Kavanaugh, turned around and said he did not believe that it was a significant burden placed on the 17-year-old girl. So on the one hand, we can't challenge the idea that signing a form is some kind of religious burden. And then on the other hand, we have the idea that locking a 17-year-old girl up and preventing her having access to medical services to get an abortion, that is suddenly not a burden that the court is considering significant. It makes no sense. Similarly, this prevalence of religion, the Supreme Court case of Trump versus Hawaii, which was on the Muslim ban. The court turned around and said, well, we don't really know this is a Muslim ban. And they decided to completely ignore every single comment by our president saying, when I get into power, I'm going to completely ban Muslims from coming into the country. Yet when there was a similar religious type case, we look at the Masterpiece Cake Shop case, the bakery out in Colorado that wouldn't serve the same-sex couple. That baker, the punishment against him was dismissed by the Supreme Court because they took the words of an earlier official and said how important it was because it showed his intent to discriminate against religion. So on the one hand, we are ignoring the words of the president because those don't count in this, but on the other hand, we're forcing things in there. The Supreme Court is now packed. Everyone talks about a 5-4 balance on this. There is no 5-4 balance on the court. If you compare it back to earlier courts, this is a 6-3 conservative split, or possibly even a 7-2 conservative split. This is the court that has moved the most conservative and the most pro-religious that we have seen. And it's not just the retirement of Justice Kennedy that's done this. This has been a long, long time coming. Many cases that Justice Kennedy were on came down against us. This is a situation as well that's going to get a lot worse before it gets better. Justice Ginsburg, I don't know if we've all been seeing the news on this. Third time having cancerous cells removed from her. We cannot go on relying on a 90-year-old woman who's a 3-time cancer survivor to live forever to defend us. And if it's in the next 2 years, with the current Senate and the current president, that Ginsburg is no longer on the bench, we're going to get another figure along the lines of Kavanaugh, along the lines of Alito, along the lines of Gorsuch, along the lines of Thomas, that will sit on that court for 20, 30, 40 years and make decisions. So where is the good news? The courts of appeal and the district courts have got to be better. Unfortunately, they're not. They're worse. If we look at the appeals courts and the district courts, there are 179 seats on the courts of appeals around the country. 21 of them, and that number may be slightly out of date, 21 of them are vacant. District courts, 677 seats, 121 of them are vacant. Those are to be filled by this president and this Senate. They sit for life. Over 15% of these seats are vacant and can be filled. And there's nothing that in the secular movement we can do to stop them being filled by people who will work against us and against our interests. Okay, I said Washington's been changing. No better way of looking at that than these are every Supreme Court justice who's come up for nomination. I think in my lifetime, there may have been a couple before Stevens. But you look at the earlier ones, and there's a very, very broad level of bipartisanship down here. Until we get to Bork. Do people remember Robert Bork? Yep. First guy anybody remembers who was actually rejected by the Senate for the Supreme Court. Kennedy then took that seat, 97-0. Souter, 90-9. Thomas comes along, very credible accusations of sexual assault against and sexual harassment of a colleague, 52-48. But then we go back to, again, 96-3, 87-9. But as we start getting more extreme Supreme Court justices like Alito, we can see the split. We then see with the two Obama nominations, Sotomayor and Kagan, how there is a core of Republicans who would have voted against anybody who'd been nominated for that seat. We then come down to the utter break from tradition of Garland not even getting a hearing, and then Gorsuch and Kavanaugh. So we're facing partisanship in the judicial system that we've never seen before. The administration itself is, how shall we say, interesting. We are looking at an administration that it's going to go down in history for its lack of talent and lack of ability. The revolving door, anybody who seems to have a spine or any degree of intelligence resigns in the near future. And we are left with people. Fortunately, now Scott Pruitt has gone from the EPA, but he's going to be replaced by somebody just as bad. In fact, the hearings were today, I think, for his replacement. Betsy DeVos in education. Our president has put people into offices whose express intention is to destroy the department in which they're saying. We're seeing this with the role of agencies in this. You know, the FDA and the FTC regulating. We work with them a lot because they regulate the labeling and advertising of drugs. And when we've been working on homeopathy, on that. I never wanted to sue CVS. I tried to get the FDA and the FTC to do their job. We were told this is not going to happen. There is no desire in the current administration to enforce even the regulations that exist, let alone make stronger regulations. Seeing it in the EPA, Health and Human Services. Again, the role of religion coming in here. Title 10 is the nationwide program, the only federal birth control program. It provides contraception and contraception advice to low-income women across the country. They've now imposed what we call a gag rule on it, that the word abortion can't be mentioned in those discussions. No referrals to abortion can be given. We're seeing policies coming out to do with healthcare services providing these religious exemptions, that people don't have to provide healthcare to people they find sinful in some way. And this is affecting women's healthcare, this is affecting the healthcare given to LGBT people. So there's this massive shift. So how is this affecting us in the courts? Well, if I'm being apocalyptic on this, we're talking about the end of precedent. We have looked over the last 80 years, since that moment in the New Deal I talked about, in a general shift that went through the New Deal, the civil rights movement, the women's rights movement, LGBTQ rights, and there's been consistent themes running through that. We've seen increases in individual rights as opposed to the government. The law is protecting more individual rights, whether it's the right to an abortion, the right to marry who you choose, the right to eat at any restaurant without being discriminated against based on your race, based on your religion, based on your gender. We've also seen an increased role for the federal government as opposed to state governments. I mean, we only have to think back to the civil rights eras. What was the problem in the civil rights eras? It was that state governments were actively discriminating against, and it required the federal government to step in and say no. And we're seeing increased respect for minority positions, whether those are minority religions, sexual orientations, races. The idea that these inherent factors in you should not be used to legally discriminate against you. Unfortunately, this seems to be just rolled back. And what I'm going to do for the rest of the time is I'm going to address the individual issues that we are fighting on and where I see them going over the next few years. Abortion is possibly the key issue that people talk about in this way. Utterly critical. And everybody talks about Roe versus Wade. Will the new Supreme Court justice overturn Roe versus Wade? Actually, Roe versus Wade isn't the law of the land. It's already been very heavily restricted. It was restricted in Planned Parenthood versus Casey and then in Gonzalez versus Carhart. But the basic right is still there. The Supreme Court has said the federal Constitution guarantees a woman the right to terminate her pregnancy at least early in the pregnancy. And that's been seen as a fundamental right on this. But the anti-choice people have been fighting this with historically what they've used as salami tactics. The idea that rather than ban abortion, rather than take the whole salami, you take a little slice off the end of the salami, and then another little slice, and then another little slice, and pretty soon you're down to a tiny nub of salami, and nobody realizes it because each change is so small. And that's what we've been seeing. The number of abortion clinics in this country has dramatically decreased. There are states, I don't believe there's a state with none left, although that might have changed over the last 6 months. But states like Missouri, I believe, are down to one abortion clinic, one clinic that performs abortions for the entire state. And what's happened on that is TRAP laws. TRAP, T-R-A-P, targeted restriction on abortion providers. So they passed law after law. They realized we can't ban abortion because the Supreme Court says we're not allowed to ban abortion. But instead we'll say that if you want to perform an abortion in a clinic, the corridors have to be 3.5 foot wide. So that means any clinic that exists at the moment with corridors less than 3.5 feet, which mysteriously turns out to be every clinic in the state, has to knock itself down and rebuild itself with those walls, with those new restrictions. So those restrictions we fought, and we were up against them. The most recent case of Whole Women's Health, a series of the most ridiculous restrictions in Texas ever. And we won that in the Supreme Court, but all the time we're fighting it because it came back to the states and they passed them again and again. But that's changed now. With Justice Kavanaugh on the Supreme Court, Justice Gorsuch and Justice Kavanaugh, they now believe they have a majority on the Supreme Court to overturn the fundamental right to abortion. And so we're seeing states passing the most restrictive anti-abortion laws that we've seen for years. Ohio just passed a heartbeat bill, which criminalizes all abortion after 6 weeks, when the majority of people don't even know they are pregnant at the time when the limit on when they can have an abortion is. And what we're seeing is a race to the Supreme Court. States know these laws are currently unconstitutional, but they want to be the first one to get the case up to the Supreme Court where they think they're going to win it. And unfortunately, they may well be right on they're going to win it. Personhood laws. Have we heard about personhood laws? I'm not even sure if New York State has proposed one of these yet, but a lot of states are trying these. Personhood laws they seem very benign on the surface. What they tend to do is to define life as beginning at the moment, not just life, but a person exists at the moment of conception. And when these get passed, they tend not to have immediate effect because They can't ban abortion because the Supreme Court says they're not allowed to. But when you are passing a law saying that human life begins at the moment of conception, you're setting things up for when the Supreme Court overturns Roe and its other cases. Because if that's part of a state's constitution, if that's part of a state's law, then anyone performing an abortion is guilty of murder automatically. We're looking at these because actually this might provide us with quite an amusing opportunity. Because if a newly conceived fetus, a zygote, counts as a person, is a woman allowed to drive in the HOV lane, for example, on this? I'm not sure the law can deal with this, and I don't think they've really thought this through. And it's actually one of the few advantages we have in this is that the religious fundamentalists are not the smartest people in the world. I mean, they probably wouldn't be religious fundamentalists if they were particularly smart people. But they're not, and they tend to do things like this that make not a lot of sense. So we're going to be looking at the personhood things. What's going to happen on abortion rights? Abortion rights are going to be further restricted. When cases go up to the Supreme Court, we're going to have a very hard time fighting against them. Religious exemptions, and I talked earlier about the Hobby Lobby case and the Masterpiece Cake Shop case, the Colorado Baker case. What the Supreme Court basically kicked this case. They gave up. They didn't want to decide it because they didn't want to turn around and say you get to ignore the law because you don't like gay people. But on the other hand, they kind of sympathized with them, so they just turned around and invented this idea that he hadn't received a fair hearing. But we're about to see this whole thing over again because, yet again, people have been going to him requesting that he makes certain cakes, and he's refusing. So wait until you see, Masterpiece Cake Shop Part 2 on this. It was the same in Hobby Lobby as well, the idea that as a corporation you can somehow be religious and not provide this. So what we're going to see over the next, this one's going to be very quick. We're going to see lots of cases of people claiming exemptions to what we call laws of general applicability. So these are laws that everyone works under, and they're going to say, I don't have to obey this law because of my religion. Obviously, there are immediate problems on that in that this is favoring religion over non-religion. But it's going to go deeper than that. And we're going to end up with these two particular questions. What religions are going to be protected? I mean, when we look at it, they claim that they're going to be defending all religions, but we know that's not going to happen. It's the crazy religions aren't going to be, it's going to be the majority religions. It's the Supreme Court and lower courts understands you if you turn around and say, I think contraception is a sin. Because at the time they had 5 Catholics on the court, now they have 4 Catholics on the court. That's something that resonates with them. They understand if you turn around and say, my religion does not allow me to provide a cake to a same-sex couple, because they come from a religious background that has historically discriminated against LGBT individuals. But what's going to happen when religions that don't sit in the mainstream start making these claims? We've already seen this with Pastafarianism and the Church the Flying Spaghetti Monster. When an individual, has been claimed, an individual in Nebraska claimed the right to hold meetings. He was in prison and claimed the right to hold Pastafarian meetings. And the federal court turned around and said, no, you don't get this. You aren't a real religion. You're a made-up religion, which there are some kind of questions when they get, you're a made-up religion for the purpose of satire. So the courts are going to be sitting, and they're going to be trying to determine what is a real religion, what is a real religious belief. At the moment, it's likely that Judaism and Islam will fall on the right side of that. But you will get questions on things like kosher and halal slaughtering of animals. And we saw this down in Florida. The city of the city of Hialeah passed laws that were deliberately targeted at followers of Santeria. So it's the minority religions that are going to suffer. And not just minority religions, let's be honest. It's going to be used to target non-religious communities, I guess. And also, what exemptions on this? Again, it's whatever the court thinks is going to be reasonable. They think it's reasonable for a corporation not to provide contraception to women. Why do they think it's reasonable? Because, let's be honest, judges tend to be old white men who have never needed to take oral contraception. But what about other things? What if it's Scientology that doesn't want to provide insurance coverage for mental health care because that's against Scientology? What if it's a Jewish employer or an Islamic employer who doesn't want to provide coverage for certain vaccinations that include pork products? Or a Hindu employer doesn't want to provide insurance for anything that's cow-based on this. Those exemptions, the further they are out of the mainstream, the less likely they are to be supported. And so what it's going to be is it's going to be what people think of as reasonable. This is as close, by the way, this section is as close as I come to being the good in the good, the bad, and the ugly. And only on one issue in particular. These cases where we're going to see gay rights cases, and I'll use gay rights as an overarching term on this, and I apologize, I don't mean to be exclusive on that. We're going to see them in religious exemptions. It's going to be the county clerk who doesn't want to provide a wedding license. It's going to be the baker who doesn't want to bake a cake. It's going to be the pediatrician who doesn't want to provide healthcare services to the daughter of a lesbian couple in Michigan, I believe. So these are where we're going to see, and we've talked about these religion exemption cases on that. The reason I am somewhat comfortable here is that we have, to a large extent, won. You know, we won the right to same-sex marriage across all 50 states of the country. And that was a huge change on this. That's not going away. I think however much this Supreme Court may want to roll that back, it's just impractical to turn around. What happens? What happens to the hundreds of thousands of same-sex couples who have already got married? Do you turn around and say, you're not married anymore? What happens to insurance policies? What happens to joint mortgages? It just doesn't make any sense for them to change this. So they're going to have to try and look elsewhere. And the community that's probably going to suffer on that is the transgender community, because that's where they're going to take the culture war fight onto this. I think any lawyer who tells you they know what's going to happen with transgender cases going to federal court is lying to you, because there just isn't enough data out there for us to know the way courts are going to decide. I do know they're going to be hostile to the transgender community. And that's, I think, that tells you there's a very important distinction to be drawn here. Courts, when we look at courts and we look at the Constitution, we have this idea of something that's very independent. And courts think they're very independent, but they're really not. They're affected by the same things that affect you and me. Why did same-sex marriage become legal? Because it was time. Because the question had been being put, and mainly because people didn't care enough to stop it anymore. That most people realized, most people had gay friends, gay family members, and they looked at them and they said, you know what? My marriage isn't going to be affected if they can get married. They should be allowed to be just as miserable as I am and, suffer the divorces, suffer everything. It really got to the stage that society was ready for this as an idea. And we're seeing this with transgender rights, and they're moving forward. But I don't think transgender rights are at the same level of public acceptance yet as gay rights are. And so if the religious right wants a group to target, they will pick on a vulnerable group. And at the moment, unfortunately, and it's going to be a very hard battle for those of us who believe in, on the one hand, science-based policies, and on the other hand, treating people with basic human dignity. It's going to be a very hard battle on that. And I think we are facing some negative decisions there. I wish we weren't. Church-state separation. Very big with us in DC at the moment, the Bladensburg Cross case. Have people heard about this? This is a war memorial, First World War memorial in Maryland, very close to DC, in fact, and it is one huge-ass concrete cross. 40 foot, 60 foot, one of the two, and it is slap bang beside a public road on public land. And the arguments are, they'd be funny if they weren't so dangerous. The idea is that this isn't endorsing religion because it's not a religious symbol. If a cross isn't a religious symbol, I wonder why people get so upset when an art exhibit has a cross submerged in a jar of urine. That is offensive, and it's meant to be offensive. It's offensive because a cross is so obviously a religious symbol. But this is going up in front of the Supreme Court. It's going up in a couple of months. Well, our brief is due in about a month's time. And I hate to tell you this, we're going to lose. The Supreme Court is going to rule that this cross can stay there. I don't know how they're going to do it because they have to use the most twisted, tortuous logic or lack of logic to come to this decision. But they'll turn around and say that this is not a government endorsement of religion, somehow. And what's going to happen is we are going to lose what has been the cornerstone of church-state separation litigation for the last 40, almost 50 years, which is called the Lemon Test. So what the Lemon Test does is it asks 3 questions. It turns around and says, does the government action have a secular purpose? So here with the Bladensburg Cross, what would their secular purpose be? Well, they claim the secular purpose is memorializing the dead of the First World War. Memorializing, I mean, it's kind of offensive to say that a Jewish soldier or an Islamic soldier is memorialized by a damn great cross. But that's what they claim the secular purpose is. So number 1, does it have a secular purpose? Number 2, does it have the primary effect of advancing or hindering religion? They would say that displaying a huge cross on government property does not advance religion. We'd be arguing pretty strongly that, hey, if you put the 10 Commandments up, if you put a cross up, if you put "In God We Trust" up on the walls, you're trying to advance religion. And third, does it unnecessarily entangle government in religion? You only have to fail one of those 3 categories for it to be held unconstitutional under the Lemon Test. The religious right loathe the Lemon Test. They've always hated the Lemon Test. They think it banishes religion from the public square. So they're going to overturn that, almost certainly. And it's been replaced by a couple of things they've been trying to. On the one hand, the endorsement test. Does the government action give the impression that government is endorsing religion? So if you have a prayer at a high school graduation, it seems pretty much that that's the school endorsing that religion. Then more recently, the coercion test. And this was Justice Kennedy's little baby, which is anybody being forced into religious activity on this. What are they going to replace it with? Well, unfortunately, we don't know. And they could replace it with some very bad things indeed. A lot of what they're going to be pushing is this notion of history. And you've heard them prepping this argument for years, that this isn't really religion. It's American history. It's the history of the nation. We have Christmas as a public holiday because it's part of our history. We have the president having a national day of prayer because presidents have done it in the past, that this is our history, that we were founded as a Christian nation, which we weren't. But this is the story. And it's tied in with this idea of ceremonial deism, that some things just really aren't worth worrying about and they're not really religion. Like putting in God we trust on the currency isn't really religion somehow. Or making it the national motto and putting it on the walls of schools isn't really religion. It's just ceremonial. If it's ceremonial, why do they get so het up about it, is the question I asked. So the battle we're coming down to, and this should scare people possibly more than anything else I've said already, is we're having a fight over what the meaning of the Establishment Clause is. There are people who turn around and say that the Establishment Clause was written to say government cannot set up a state religion. They can't say Christianity is the state religion, or even more specifically, they can't say the Church of England, the Episcopalian Church, is the state church. We have always argued, the secular community has argued, and a couple of people on our side include Thomas Jefferson and James Madison, who made the argument that no, it's not only that the government can't prefer Christianity over Islam. It's not only that the government can't prefer Catholicism over Protestantism, it's the government cannot prefer religion over non-religion. So not only do they have to be neutral among religions, they have to be neutral between religion and non-religion. And the Supreme Court came down and said we were right in a case called Epperson versus Arkansas. If we lose that, and it's distinctly possible we will lose that in the very near future, the government will be allowed to favor the notion of religion. So what's that going to mean? Well, it's going to mean a lot more religious displays in places because, hey, it's just a cross. It's not like a specific Catholic cross or Protestant cross. We're going to see all these multi-faith things. We're going to see religion being taught in schools as long as they're not saying be a Baptist. So this is the fight we're having, and it's problematic. So, sorry, one other thing on this. Funding cases. Trinity Lutheran, the Supreme Court turned around and said the state has to provide funding, the state of Missouri has to provide funding for a playground that's owned by a church, because as part of this program to make playgrounds safer. So we're going to see churches and other groups applying for government funding on this time and time again, and I'm not sure we're going to be able to stop them. But I'm going to try and be a little bit upbeat. Not probably very successfully, but I'll try. So where do we go from here? And I used to love watching Dora the Explorer when I was way too old to be watching it, and there was always this map and things. But the first question we have to ask ourselves is, where should we be bringing our cases? We're going to have a hard time in the federal courts going forward with these new understandings. So maybe we need to be looking at the state court system. Certain states have much stronger, they're called no-aid provisions than others, laws which say no taxpayer money can be used to support religions. So we need to be there. Same on abortion issues. We need to be fighting these in the states. Unfortunately, what that means is that we are turning our back on people in certain parts of the country. So yes, we can fight to defend abortion rights in New York state courts. We can fight to defend abortion rights in California state courts, Illinois state courts, Washington state courts. I don't think we're going to have the same success in Alabama and in Georgia on these. And I'm not comfortable with turning around to the people of Alabama and the people of Georgia and saying, tough, you should live somewhere more progressive. What kind of cases do we bring? And this is going to be very hard for the secular movement as a whole. Because we have historically brought certain types of cases, and you've seen it's the Ten Commandments being displayed in the courthouse. It's the prayer at the high school football game. It's the War Memorial Cross. And we may well have to move away from a lot of those cases. What should we look to? Well, we've been doing this at CFI already. We've started looking at cases which are about inclusion rather than taking things away from people. Rather than saying, you can't have that display, you can't have that War Memorial Cross. We look at situations where there is religious privilege and we say, let us, the non-religious, have equal rights. Let us sit at the table. Yes, religious people can perform marriages. Hey, how about letting our trained people perform marriages as well? And it's a lot less threatening when you say, give us the same rights as other people, rather than saying, take that away from these people. We're also looking very heavily at free speech cases on it as well. The right to free speech in there is very closely tied into these religion cases. We're being told we need to fight defensively, and that's right. We've got to be very careful what cases we bring, because the idea of losing these cases can affect you for 10, 20, 30, 40 years. But it's not just a matter of not bringing any cases, because believe me, groups like the Alliance Defending Freedom and the Beckett Fund for Religious Liberty and the ACLJ, why they can't invent their own names, they have to piggyback on other names. It really bugs me. Liberty Counsel, all these people, they are going to be bringing the cases. They're going to be bringing the cases. They're going to be seeking religious exemptions, so we're going to have to fight them. We're going to be looking for new areas to explore. This is again what we're doing at CFI. We're looking to explore the consumer protection area by challenging pseudoscience, by challenging alternative medicine. But we've got to get better in certain areas. We need to tell a better story. For the longest time, we have been the smart guys in the room. We've been the erudite guys. We've been the people who stood up there, and honestly, we've been a little bit preachy about it because we know we've been right. And we've turned around and said, this is ridiculous. These people, they want to put up a cross in the courthouse. They've obviously never read the Constitution. And in a case like that, it works. But then we came to this Trinity Lutheran case, and we made this argument. We made a brilliant argument, though I say it myself. And we were right that the Constitution required this, that Missouri law required this. What did the church come along with their argument? It was like, look, here are 6-year-old kids who are falling off the jungle gym and getting their knee scraped. Who wants to doesn't everybody want to stop 6-year-old kids crying? And they told a better story than we did, and so they won. We need to start telling stories. We need to start showing how real people are affected by religious privilege. How the lesbian couple in Michigan whose doctor refused to treat their 6-month-old daughter. We need to put that 6-month-old daughter front and center and say, this is who is being harmed. This is a 6-month-old baby, and religious privilege is denying her medical attention. We need to put, and this is where the same-sex marriage movement got it right and was so wonderfully successful, because they made it about individuals, they made it about people, they made it about families. And we need to stop when we're presenting in the courts. We need to stop making it about legal principles and the Constitution. Those things are important, but we need to show how those impact individuals. We need to look for areas where we have popular support on that. And we've seen this recently. Like, Trump was getting significant popular support for his immigration policies until what happened? Until he started putting children in cages, in camps. Because people aren't going to accept that. They're not going to look at the details of the situation. Because people know it is wrong to separate a child from that child's parents and lock them up in cages. It's how we did it on same-sex marriage as well, because we had public support on that. So that's all tied in with the telling of the stories. We need to form alliances. And we look at this. We formed alliances with the LGBT movement. March for Science is a classic example of this. The Women's March. We need to work at times with the faith-based community as we did on some of these issues. So we need to pick our allies. We're going to be facing an incredibly tough time for the next 10, 20, 40, 50 years. But there's areas we can win, and I hope I've shown that.
Thanks for watching. If you liked this video, be sure to give it a thumbs up and share it with your friends. Don't forget to subscribe to the channel and ring that bell to be notified about new videos. You can follow us on social media, and if you really love what we do, consider supporting us with a donation. Links to all that good stuff is in the description below.